A manufacturer has a duty to design products so as to eliminate any unreasonable risk of foreseeable injuries. In Prentis v. Yale Manufacturing, the Michigan Supreme Court considered what legal standard to apply to defective design cases. John Prentis worked as a foreman in the parts department of an automobile dealership. His forklift, manufactured by Yale Manufacturing Company, weighed about 2,000 pounds. The forklift was a stand-up or walking model called a walkie high-low, with a hand-controlled dead man switch that was supposed to turn it off if the operator let go of the handle or controls. This forklift was powered by a large battery that was recharged every night. The charge tended to run out before the end of the day, causing the machine to operate erratically. Prentis could get it to come back to life by jiggling the handle, but this sometimes caused it to jolt forward. It had already crashed through the garage door several times. One afternoon, Prentis had just used the forklift to place an engine in a delivery van when the battery ran low. Prentis jiggled the handle. The forklift surged forward, rolled past him, and crashed into a car. Prentis fell over. He broke his hip when he hit the ground. Prentis sued Yale for negligence and breach of implied warranty. He argued that Yale's forklift design was defective because it didn't provide a seat for the operator. The trial judge instructed the jury on a unified standard of liability that combined the elements of proof under both negligence and implied warranty theories. The jury found that Yale's forklift design wasn't defective. The Court of Appeals reversed, holding that the trial court should have instructed the jury separately on negligence and breach of implied warranty. Yale appealed to the Michigan Supreme Court.